Hi, everyone.
Thanks for coming.
Yes, we will take questions during the presentation. We are pretty good at following the breadcrumbs back to where we were. If we feel like we're getting off track, though, we're going to take control, but feel free to ask questions. With this caveat, you may be asking a question about your child or a student you're working with, and I won't know or Julie won't know all of the facts. And so keep it general, both for the benefit of everyone else so that they can learn from whatever the circumstance is, and also because we're not in a position to give advice about a child that we don't know anything about other than a question. So just please keep those things in mind. The only other thing is that, we want this to be interactive as much as possible because we want you to be learning from this experience, but we do have some excerpts planned from the book. And typically we would be starting off by telling you all how we met each other, but that's part of the first reading. So I'm going to start with what we call our introduction, which is the OneTwo Punch. And I understand the library here has these books available, which is great. So you can take them out here. You can also get them on Amazon or on Barnes & Noble, I believe. So this is our introduction, the OneTwo Punch. It was the mid-1990s. Jen was a brand new, fresh out of the box attorney working in her father's civil rights law office. Bill Laviano was a force to be reckoned with, a 400-pound Italian-American litigator with graying beard and a brain too big for most people to manage and an ego to match. Julie's son had just been diagnosed with autism at a time when few people knew what it was or talked about it. She and her husband were looking for an applied behavioral analysis ABA program for their son, a particular methodology that back then was virtually unheard of in public schools. Only one case had been litigated in Connecticut for such a program. They hired Bill and began a hard, acrimonious legal battle with their town. Several days into the due process hearing, a scheduling conflict arose. Everybody was available for a hearing date except Bill. "No problem," he said. "I can send my daughter Jenny." Julie and her husband exchanged worried looks. They asked to speak with Bill outside the hearing room when they expressed their concerns about having their son's case handed over to someone they'd never met, who they'd never heard of, in the middle of the case. Bill didn't take it well. He was a man who would take on City Hall, state and federal governments, the Catholic Church, the state police, and virtually any company or institution without flinching, but an attack on any of his four daughters led him to level him in an instant. How dare Julie and her husband question the capability of his daughter? He took their check for several $1,000s and ripped it up in front of their faces. This is a true story. Julie and her husband were speechless, but they knew they had to accept this unknown young lawyer for a day of the hearing or try to find another law firm mid-trial. Jen was less than thrilled to hear her father's solution. He'd thrown her into more than a few of these difficult situations in the few months since she'd been sworn into the bar, and despite his efforts to convince her that Julie and her husband were in the wrong, Jen knew better. They had every reason to be furious, she told her father, and by the way, thanks so much. This is how Jen and Julie met. They hit it off immediately. Fast forward more than a decade. Bill has passed away, and Jen has continued working as a civil rights lawyer, focusing her practice entirely on special education cases. Julie has become a successful professional advocate working with families to secure appropriate special education services. She also tries to bring disabilities into the media's attention, but has faced an uphill battle, becoming outraged when one of the producers on a local TV news station told her that our audience just isn't interested in disabilities. Julie is not a woman who takes no for an answer. That's when it dawned on her. She needed someone to pair up with her in her advocacy work who could provide legal expertise to fight the bias she continued to encounter. She needed a lawyer, and she just happened to know one. Julie pursued Jen for 2 years, trying to convince her to join forces with her. Jen was reluctant, too busy, and sure that if people really wanted to hear from a lawyer, they'd hire one. But Julie was persistent. She finally convinced Jen by saying, "I'm the parent, you're the lawyer, together we're the 1-2 punch." With Jen on board, they worked together doing everything from radio interviews to blogging, and ultimately created an award-winning video-based website called YourSpecialEducationRights.com. Their mission is to make sure that parents of children with disabilities know their rights and can apply them so that the outcomes for those kids dramatically improve. And what happened with Julie's case? She ultimately prevailed. Her son received an excellent program for his educational years, and he is now thriving in the adult world.
Yes, he is.
Yes,
Any
he is.
questions so far? Okay.
That is a true story.
That is a true story. We normally tell everybody how we met, but that chapter actually tells you how we met. So I am going to now read a note from the authors. We've written this book primarily for parents. However, one of the things we always say when we present to parent groups is this: we know we're jaded. Parents often hire us when their child is in a crisis or when their relationship with their school district, their school has reached a point where they no longer feel able to communicate without a professional advocate or attorney. This is not the norm. Given that, we would like to say a word to educators and administrators who are reading this book. We came close to naming this book Your Special Education Rights: What You Don't Know Can Hurt You. However, we felt that title placed the blame for not understanding their rights on parents, which we did not think was entirely fair. After all, Congress requires school districts to inform parents of their rights. We therefore then came awfully close to the title, Your Special Education Rights: What Your School District Won't Tell You. But that seemed too harsh as well. We ultimately decided to emphasize that schools may not tell parents certain things, rather than assuming that they won't. We realize that highlighting what school districts might not tell parents may have the unintended consequence of leaving educators and administrators with the impression that we have written this book to bash school districts. We did not. In fact, we are both products of public education, and we believe in it strongly. We recognize that the vast majority of people who choose to become teachers do so because they love children and they care about education. We believe that most administrators are trying their best under enormous financial, political, and legal pressure. Our sincere hope is that our candid account does not alienate educators and administrators, but rather raises awareness of how difficult it can be to navigate the special education system. Our goal is to empower the empowerment of parents, so that they can work shoulder to shoulder with their school districts on behalf of their child, rather than against them. Do you want me to just read the whole paragraph?
No, I think we're probably a good springboard
Yeah.
for
Right.
our conversation.
Right.
So that leads us to what we hope is what anyone gets out of this book, which is that we realize that very unfortunately, the only enforcers of the IDEA, which is the federal special education law, are parents. There is no special ed 911 I can call if someone calls me and says my child's rights were violated. There's not a way to enforce this other than through parents doing it. Neither the state nor federal governments are really enforcing the statute. They check on certain things and they monitor certain things and they take data, but they do so in a way that sometimes is counterproductive, in my opinion, and sometimes is taking data on the very minimal things. So I'll give you an example, and I'm sure the teachers and educators in the audience will know what I'm talking about. Connecticut puts a lot of pressure on school districts to make sure that they're holding their annual reviews. The law requires that the IEP meeting, the PPT in Connecticut, is held at least once a year, right? So the state is all over school districts to make sure that happens. Well, in my experience, and this 23 years now I've been doing this as a lawyer and mentored under my dad well before that, since I was 18, that's not the problem. I mean, it's pretty rare that we don't have an annual review. And so what's happening is that everyone on the team agrees we're waiting another 2-3 weeks until we get the report back, but the state is all over the school district to make sure they can check off the box that you had your annual review, even if everyone agrees that we'd like to have it in 3 weeks. And it's very frustrating for a parent attorney because I know the case law says that if a school district is faced with a choice of a violation, it's better that you violate the obligation to hold the meeting annually than that you violate not having the parent at that meeting if they say I can't be there or I don't want to be there until we have all the information. But it's a Hobson's choice. It's a difficult situation. Why is that the thing that the state is monitoring? It's easy to monitor. It's a box you check off. It's much harder to monitor quality. It's much harder to monitor whether or not there is a truly collaborative relationship between a parent and a school district. That's very hard to monitor. So who enforces the statute? Parents do. Parents enforce it by exercising their rights under the law. They can do that in many ways. They can do it by speaking out at IEP meetings. That's our hope, that that's the first place that you are going to express your concerns and say, this is where I feel that my rights are not being enforced. But ultimately, they can be enforced through litigation. That's the last case scenario. That's what we hope you never have to get to, because that's not in anyone's best interest. But the reality is, like any other aspect of being a parent of a child with a disability, and Julie has said this to me many times, no parent really wants to have to become an expert on their child's disability, but they do. They become an expert on their child's disability. You're gonna have to become an expert on your rights too. Maybe not to the level where you wanna go and write a book or give a presentation or go to law school, but you're gonna have to learn them well enough to feel like you understand what's happening in that meeting and that you can enforce your rights.
Right.
Go ahead, Julie.
And you know, there's a direct correlation between the outcome of your child and your advocacy efforts. And we know that, and I think just so many parents are aware of that. And one of the reasons that we wrote this book is that we know there are a lot of, as a matter of fact, you can be inundated with information about the IDEA online and books. I mean, there's no shortfall of that. But with all of the books that we read, there were no books that told you about the things that you're never going to read in the IDEA. So this book is a combination of our 40 years of experience together between us. And it was a natural springboard from the website that we have. I in a previous lifetime, but I didn't plan to be a special education advocate, by the way. It sort of found me because I ended up advocating for my child, who's now 23 years old and has an autism spectrum disorder. But in a previous lifetime, I was a television producer, and I still, in my mind, am one. And one of the reasons I got very frustrated because there wasn't any really easily digestible way for parents to understand your special education rights in a simple way, other than reading through a book. And even sometimes when you read, you just can't get everything. So we started our website, which is a video-based website that helps parents understand their rights. And it's very girlfriendish. We talk to you like we're your friends, and we're just telling you what we think. And so this was a follow-up to our website to tell about all the things that you're never going to find written in the IDEA. So,
and we hope, and we've been told, we hope it's true, that it's very accessible as a book, that it is really boiling down to the basics, what you need to know. And I will tell you, and Julie will verify, throughout the entire time we wrote the book, as a lawyer, I'm trained to think of the 45 what ifs, right? Yes, but what if this happened, and what if this fact was different, and what if the child had this? That's how I'm trained. That's how I live and breathe my practice. And I can't tell you how many times I would be writing something, or Julie would be writing something, and I'd say, well, but in some circumstance, she'd get very angry with me, not really angry, but she'd get frustrated with me and say, Jen, parents don't need that. They can get that out of reading the statute. What they need is what the takeaway is. What's the takeaway? What's the basic information I need? Bottom line it for me. And it was very frustrating, and there were many times during the course of the writing of the book where I found myself frustrated by having to boil it down, but I'm very glad we did, because I think the number one thing we hear that we're thrilled about from parents is this is the book we wish we'd had when we started advocating for our child, because it's a lot of the learning curve that many families go through. And that is one of the frustrating imbalances of special education, that for the most part, and I'm not saying that all educators are facile on the IDA, but they receive training on it and they go to meetings all of the time, whereas parents maybe go to one a year for their child, and their learning curve is steep. And they often are not, maybe 2-3 years into the process before they start to understand even the terminology and what the alphabet soup of special education means. And that's incumbent on all of us. I mean, Julie and I included, because we attend dozens and dozens of IEP meetings, especially this time of year. In a week, we go to probably 10 a week at this time of year. It's incumbent on us to stop talking in alphabet soup, because it just adds a veil to the relationship between parents and their understanding of what the conversation is about, what their child's abilities are. So it's really important that we speak in plain terms as much as we can, knowing that this is complex law still, even
right.
still. Yeah.
So we're going to read some excerpts from some chapters in our book. And I'm going to start off with, we have a chapter called Special Education Urban Legends. And when Jen and I are in special education IEP team meetings, or 504 meetings for that matter, sometimes, and unintentionally, as we said, we're not here to bash school districts, but sometimes when you are in your own element, you're working in a school district, and you say, well, that's the way we do it here. And you've done something for so long that it goes on to the next generation of the person who works in the school district. Before you know it, people say, this is how we do it here. But when you really boil it down, some things have no basis in the law. So we actually have a chapter, as I said, called Special Education Urban Legends, and I'm going to read a couple of them to you. I'll start off the chapter by saying, simply saying something over and over again should not make people think it's true, but it does. There are so many myths in special education that a whole book could be devoted to them. These urban legends often are not being repeated to mislead a parent. The educators themselves actually believe them to be true. But they aren't, and they can truly result in harm for many kids. We have demystified these urban legends for you and are telling you the truth instead. I'm not going to read all of them, I'm just going to choose a couple of them. So one of the myths is that only intellectually disabled children can get special education. If we've heard it once, we've heard it 1,000 times. Parents are told, your child is too smart for special education, or the other oldie but goodie. Your child would never qualify for special education because he gets very good grades. No matter how you say it, or how many times you say it, it's wrong as a matter of fact and law. So the truth is that smart kids can actually get special education. You can get straight A's and still qualify for special education.
And then I'm just going to interrupt you
Please.
for a second there. So when we say that the myth is that intellectually disabled students are the only ones who receive special education services, what we mean is there's only one category under the many, there, depending on whether you look at the federal or the state, 13 or 14, depending on what you're looking at, many categories of special education. There's only one that requires that you're intellectually disabled, okay? One of the biggest barriers for families and for children and for adults, frankly, in disability advocacy is the perception, the very, very wrong perception that having a special education needs means that you're not intelligent. And it is a barrier not just to the perception of the abilities of students and therefore our expectations of them, but it's a barrier to identification.
For parents, yeah.
For parents and for educators, because what happens very often is that there are regular educators who maybe haven't had the same level of training that special educators have had, who see a student who is showing every red flag in the book that they should be referred for an evaluation. But the regular educators still have this perception, this anachronistic perception that if this kid's really, really smart, they're not a special ed kid. And it's just flat out wrong. It's flat out wrong as a matter of law. It's flat out wrong as a matter of education. It's wrong as a matter of justice and discrimination. But we can't say this enough. There's no intellectual cap for disability. There just isn't.
Right. And special education, we like to say, is more than academics. It's social, it's behavioral, it's emotional, it's adaptive. Am I missing one? And of course, academics.
Yeah, sure.
So I'm just going to read a couple more from this section. Myth. Parents have to document regression to get summer services. In fact, I was just at a PPT today where this was mentioned. School districts must provide extended school year ESY services under certain circumstances. Parents typically think of these as summer services. The IDEA notes that if a child requires ESY to receive a free appropriate public education, she must get it and it must be individualized. However, parents are often told that the only way kids get ESY services is if regression has previously been documented, and worse, they must prove the regression. This is just not so. For many students, the nature and severity of their disability requires programming year-round. Many states have provided guidance to this effect, but be prepared to counter this urban legend. If you happen to have proof of regression, feel free to share it. So the truth is that ESY services are provided to students who require it for FAPE.
And there may be some students for whom the regression and recoupment standard, is what we call it, is appropriate. But there are other students for whom the nature and severity of their disability requires something different, and it's not a question of whether they would regress without it. And in fact, the argument is that over the summer they would not just maintain programming, but be expected to continue to make progress. So like anything else, it's an individual analysis. You know, the I in IEP is individualized. So it's always going to be, let's look at the unique needs of the child and let's see whether or not this child requires this and what they require. But these kind of global rules that, oh, you have to show this or you can't get this, are always a red flag should be going up.
And there's a really great thing that you can Google. The state of Connecticut has a topic brief out called Extended School Year Criteria. If you just Google Connecticut State Department of Special Ed, ESY criteria, topic brief, any one of those words, it will pop up. It's a PDF. It will save to your download, and you'd be well served to bring that to your IEP team meeting and say, well, let's go over the ESY criteria. So the last one that I'm going to read from this is the myth. Parents like to be called mom or dad by the team. Don't call me mom. Among the many things that schools unwittingly do to diminish parents is to refer to them as mom or dad. Most IEP teams are comprised of 10 or to 20 members of staff around the table. Everyone is referred to by their names, except for the parents, who are most often referred to by their role. Parents have names and want to be called by them. The truth is that parents want to be called by their names. So not only am I a parent, and I've been through years and years and years of IEP team meetings with my own child, but I go to 10 IEP team meetings a week on most weeks. And I see that every single team, with very little exception, refers to parents as mom and dad. And sometimes parents even refer to themselves, I'm the mom. And not all people are going to agree with me, and it's okay if you don't. But I just think that when you've got all these professionals around a table, and everybody else gets to be called by their name, but only the parents are called mom and dad, even though being a mom is probably the most important thing I've ever done in my life and probably my favorite thing in the whole wide world. I'm also a professional, and I have professional thoughts and capacities, and to be able to be called by your name, I just think elevates parents to be an equal member of that team, which in fact you are. And when I work with parents, I will often say to them, if this is something you care about, right at the beginning of the meeting, you can say, my name is Susie, please call me Sue. And as a matter of fact, one of my clients did that today. And I just think it makes a big difference. And not all parents agree with me, but it's just something that really gets under my skin.
This is a good example of something that I've learned from Julie over the years, because when she first brought this to my attention, I thought, you're being very sensitive. You really. Do you have any idea how many parents come in and out of that room, and that they don't remember everything? And we had an active conversation about it, and I, I'm rather stubborn and Italian and all those things, as you probably gathered, so I was sure I was right. But I started it as a little experiment of paying attention to it and taking the time to model behavior by always referring to the parent by their first name. And believe me, same kind of volume that teams are going through. I'm walking into a meeting with parents many times a day, and I don't always, off the top of my head, remember the first name of both parents, because I'm usually talking to one most of the time. But I may not remember the father's name or the mother's name or what. But it's not that hard. The IEP is right in front of you, and both of their names are on it. And I realized it's not that hard. It's really not that hard. And so what I've started doing is I will turn to the parent and by their name. Julie, what do you think about that?
Yeah.
And constantly say their name.
Right.
And if you do that, you can't change other people's behavior until you change yours. If you start to, I've noticed a palpable difference in how a parent feels and how the team regards a parent, just by simply making them more of a human being rather than the role of the mom or the dad. Right. It's a simple little thing, and it took me a while to be convinced, but again, you were right.
Right, and if you really play it out, you'd have to go around the table and say, well, speech pathologists, what do you have to say? And psychologists, what would you like to say? And so, anyway, just that's the last one I'll read from this chapter, and we'll go on to another chapter that Jen's going to read.
Okay. So, this one's called Procedural Safeguards. Jerry Seinfeld has a great quote. We're all playing the game, but the lawyers have read the top of the box. The procedural safeguards are the rules that govern special education at the top of the box. If you've been to an IEP meeting, you were probably handed your procedural safeguards at some point during the meeting, or should have at minimum received them annually. Why? Because the school district has to provide them to you under the IDEA. They are legally obligated to do so. While they are obligated to give them to you, they probably won't explain them to you. At best, an administrator will make a casual comment at the beginning of the IEP meeting stating that they have given you your rights, and if you have questions, to let them know. Why? Because the safeguards are complicated and frankly explain that you have a lot of rights. Your school district does not necessarily want you to understand them or enforce them. If you've actually read your procedural safeguards, consider yourself among the select few, as they are daunting. It is the kind of document that makes your eyes gloss over. Parents often tell us that they have received them but have never read them. And I say this, pause, my lawyer clients tell me that. In fact, I wrote it. Even my lawyer clients tell us this. So why are we devoting a chapter to the procedural safeguards? We want you to understand the rules you and the school must follow to ensure that your child receives a free and appropriate public education, which is the cornerstone of special education. The rules include making sure you get written notice of an action proposed or refused by the district before the school actually follows through on it. The fact that parents are required to be invited to their child's IEP meeting and that the district should do its best to get them there. How you can disagree with your school district over your child's program, timelines and that you and the school district must follow over disagreements, and the procedures for resolving differences of opinion. When the school can remove your child from school. For how long and for what reasons. The fact that you can ask your child to be maintained in the last program you agreed to when your school wants to change his program, and more. It is important information, and you should become as familiar with your procedural safeguards as you can. And I'm going to just say this as politely as I can, because procedural safeguards are highly complex. They could be a course, an entire course of law school. School districts love to characterize the procedural safeguards as nitpicky. And indeed, Congress has made it clear that small procedural violations will not lead to a complete liability for school districts. In order for a procedural violation to matter, there has to be a demonstrated connection between the violation and a deprivation of a free and appropriate public education. It's what we call a nexus. But as one court noted, Congress didn't require school districts to follow the procedures as mere hoops through which the school district should jump, but rather envisioned that full parental participation in the development of a child's program and IEP would result in quality programming. So I just want to make this point. One of the things that is interesting about the IDA, and I love about it, is that sometimes a parent will call me and tell me what's happened, and it feels wrong. It just feels that there's something happened that's not fair. And I may not, in the moment, be able to cite the regulation or the section of the statute that was violated. Sometimes I can. But sometimes I just know that can't be right. That can't be allowed. That's got to be prohibited. And I'll go to that document and I will start reading, and there's almost always some section that prohibits it. It's a very instinctually fair statute. There's a lot about it that seems like it is window dressing and that it is just making paperwork for educators, but there's a reason behind a lot of it. And I myself, because I attend so many of them, I will quickly run through a page and think, oh, we can blow through that page, so that's not really important. But the page is important. There's a reason for it. The Congress sat together and came up with a reason that we have to do this. And often you will find yourself in hindsight realizing why. You'll say, we never really took the time to go through the least restrictive environment checklist. And we should have, because in this particular case, this child was really being secluded more often than they needed to be, and we didn't take the time to really talk about it. It's difficult because these meetings we all have time constraints, educators and parents, and we want to get through it. And for most parents I know, that IEP meeting is one of the most stressful experiences of their year or more if they attend many of them. But it's important that we actually pay attention to what the purpose is behind the procedural safeguards. There usually is a purpose, and the purpose usually is that it will result in quality programming.
Did you want to say a word about Endrew F?
Yes, so thank you. Julie's reminding me. So Julie and I were literally signing off on the final copy of the book when the United States Supreme Court issued its decision in the Endrew F case. The Endrew F case is the first time the United States Supreme Court has issued a decision on what the appropriate means in free and appropriate public education since what we call the Rowley case, which was in the 80s. So we're about to go to print, and not only are we having all sorts of changes in terms of the makeup of our federal government, but we have this massive decision. And I call her and she calls me, and I said, there's no way we can allow them to print this book without us begging them to at least give us a section of the book where we can explain this is now a new game in town. There's a whole change. And thankfully our publishers were kind enough to let us do that. The Endrew F decision, because it's new, it's only about a year old. It was February of last year. And I was very fortunate enough to be able to go and see the oral argument at the Supreme Court, which was fascinating and really a cool experience. The justices were all over, both lawyers like white on rice. They were really interested in this case. Here's the procedural posture of the case, and I'll give you the background, and then I'll tell you what we are taking away from it for now. But the courts will still be deciding what it means probably for many years to come. It's a very new case law, and that's how the law works, is it takes a while for us to all figure out what it means. The decision basically was the 10th Circuit, which is, so our federal system of courts is broken up into various circuits. We're in the 2nd Circuit, so Connecticut, New York, and Vermont constitute the 2nd Circuit. The 10th Circuit includes Colorado, which is the state from which the Endrew F case emanated. The case factually involved a student with autism who was educated in his public schools, was not by his parents and some outside experts' views making progress, and they pulled him and placed him unilaterally in a private program for kids with autism and sought reimbursement. The 10th Circuit had for many years been articulating a standard, and so the Rowley case, which was the Supreme Court case from the 80s, set a standard, but it wasn't really clear in every circuit what that would mean. And so in the 2nd Circuit, our standard for what appropriate meant was meaningful education. Meaningful educational benefit is what's appropriate, okay? There were other circuits that said some educational benefit. Then there was the 10th Circuit, which had articulated a disastrous standard that says that a school district meets their obligations to provide an appropriate program to a child with a disability if the program produces progress that is, quote unquote, more than merely de minimis. De minimis is a Latin term that means nothing, minimal, literally minimal. So more than minimal is 0 plus some, is what that means. And the justice who wrote the decision for the 10th Circuit was actually Gorsuch. So there's a whole interesting story here. And he was the one from the 10th Circuit who wrote that, who's now a Supreme Court justice. So the Endrew F case finally went up to the Supreme Court because there was something called a split in the circuits. The Supreme Court doesn't hear most cases. Many people apply to have their case heard by the Supreme Court every year, and they deny almost all of them. But they grant certiorari on certain situations, one of which is if there is an inconsistent application of the law from state to state or circuit to circuit. It's called a split in the circuits. So there was a split in the circuits. Some circuits you had a standard of appropriateness that was meaningful, and others more than merely de minimis. So the Supreme Court said, yes, we will hear this case. And we were nervous, all of us in the community, because we didn't know how it would shake out. And frankly, so few cases get to the Supreme Court that are special education cases, even get to the appellate courts, that we worry that most courts don't have a real understanding of education or special education or what's happening on the ground in IEP meetings, and that's all of us in this community worry about that. So we were really nervous. And what was really edifying was that with the assistance of a lot of amici, meaning friends of the court, briefs that various disability rights organizations filed with the court to explain why this decision was really important, including COPA, which is the Council of Parent Attorneys and Advocates, on which I'm the board. They understood it. The questions made it clear that they understood it. They were asking really insightful questions about, did Congress really want us to spend all of this money for merely more than de minimis? Really? For 40 years, we've been making school districts comply with these procedures and teachers learn these things and students get these services. We were going to do that just so that really it's more than de minimis. And they really were concerned about it. We walked out of there feeling good about it, but you never know. Mm-hmm. They did issue the decision in favor of the parent and struck down that standard and said that that is not what Congress envisioned, that standard is far too low. And in fact, the language of the court has very promising language for those of us who are interested in making sure that we push the bar forward for our expectations for students with disabilities. So it has language like ambitious, very much focused on the unique needs of the child. So it's in light of the circumstances of the child is also language from the court. But it is clear that Congress, having reauthorized the statute many times and increasing the bar, that the court is saying, yes, we expect these programs to be ambitious programs, we expect outcomes. We really, and some of us in the community are referring to this decision as our Brown versus Board of Education. We think it is a huge game changer. How it shakes out over time, we don't know, and certainly those of us who are in circuits like ours, who already had a fairly robust standard, aren't sure that day to day it'll make a difference, but it certainly will in many parts of this country where the standard was much lower. So it's exciting. It is unknown as a quantity at this point what will happen. But certainly, from my perspective, it changes very much those IEP meetings in terms of goals, because the court was very clear that goals themselves are supposed to be, and I mean as in goals and objectives, are supposed to be ambitious. And we have often seen, and I think my view of it over many years is that the benefit of technology, of things like IEP Direct and other software programs that allow schools to boilerplate goals and objectives, has not necessarily been a friend to individualized programming. And so I think we need to be more thoughtful about the unique needs of the child and being ambitious about what's going to happen at the end of the year. Where is that child going to be? So it's exciting. We'll see where it lands, though.
Okay, so I'm going to go on to the next chapter, page 87. Let me get to page 87. And I think we're going to add one at the end to read a little bit of one of our letters, because I know
Sure.
that was something they wanted us to
Yep.
include. So I'm going to read a little bit from a chapter called The Right to a Second Opinion. Your district must evaluate your child in all suspected areas of disability, according to the IDEA. Further, this type of thorough evaluation must occur at least every 3 years, which is referred to as a triennial, although evaluations can be undertaken more frequently if requested or needed. If your child has been evaluated by your school district, you may not think that the testing is accurate or the result is a fair description of your child's strengths, weaknesses, or educational needs. This may occur during an initial evaluation when you are first determining if your child is eligible for special education services, or after a reevaluation many years into the process. So what do you do if you disagree with some or all of your school's testing? Consider using one of the most powerful tools in a parent's special education toolbox, the right to the Independent Educational Evaluation, or the IEE. The IEE is essentially your right as a parent to obtain a second opinion about your child from an outside evaluator who's paid by the school district but chosen by you. The law surrounding IEEs is highly complex, and there are few aspects of special education litigation fraught with more confusion than this one. For example, school administrators will often ask parents why they disagree with the school district's evaluations. Parents are not required by law to answer this question, and for good reason. Congress, when developing the IDEA, recognized that parents are not usually educators who understand all of the complexities of the assessments and are not able to articulate why they disagree. We've heard of situations where schools have told parents that they will not grant the IEE unless the parents can explain why they disagree with the evaluation. This is not a hoop you have to jump through by law. And we're obviously not reading all of the chapters, but in our own state, we've got new guidance on IEEs, and so that's usually, some parents don't even, we work with so many parents who hire us or retain us, and they may know nothing about special education and don't understand that this is a right. But we thought it was important to say a word about it.
Very. Julie and I both feel that the right to an independent evaluation is probably the strongest right a parent has under the law, and the most important to utilize, because it is where you will get an outside view of your child's abilities, disabilities, et cetera. The guidance that the state has recently put out, many of us in the parent community have real concerns about whether it is accurate. And just because the state says something is so does not mean it would meet federal legal requirements, just for your information. And it's not the first time that I've had issues with how the state conveys information to school districts and to parents in terms of whether it's accurate as a matter of federal law. What I do say to educators as well is I encourage them to embrace the independent educational evaluation, because I have represented many parents who were flat out wrong about their child. Usually parents' instincts are accurate, but there are parents who just don't understand what's happening in school. Children present very differently in school, some children, than they do at home. And sometimes parents are wrong. And if the school is so certain that what they're doing is right and that the child is making progress, then they should embrace the opportunity for someone that the parents trust to tell them that. Few things make parents more distrustful of a school team than when they want an outside view of things and they're prohibited from that, including the parent wanting to observe or having their psychologist or their evaluator observe the child in school. The more you can send a message to the parents that this is an open door and we're interested in having you have information, the more likely they're to trust your recommendations. Yes, sir. So it's complex, but I'll break it down as best I can. If a parent requests the independent evaluation and the school says yes, then the school is obligated to provide to the parent the criteria that the school district uses for independent evaluations. That can be a source of some disagreement because sometimes that criteria, in our view, is not legally, because the criteria, schools can set criteria, but it can't fly in the face of a right to an independent evaluation. But the school is supposed to say, this is our criteria, and then the parent is supposed to be able to choose the evaluator as long as that person meets the district's criteria. If the school says, no, we won't agree to the independent evaluation, by law, they are required without delay to initiate a due process hearing where they defend their own testing to a hearing officer who determines whether the parent is entitled to the independent evaluation. There are many, many, many aspects of this that are even trickier than that, but those are the basics. If a parent obtains an independent evaluation, where they just go and hire someone to evaluate their child and then present the findings to the team, the school district is required to consider it. Just as they're required to consider the evaluation they pay for, they're not required to follow the recommendations of an outside evaluator. They're required to consider it. That's what the law says. Now, if a school obtains an outside evaluation and then does not follow any of the recommendations, I think their lawyer would probably advise them that's not going to look so good in a hearing, but they're not legally required to do everything the evaluator says. Does that answer your question? Okay.
And we don't bring this up to say that we're not suggesting you should willy-nilly just ask for independent evaluations on every single evaluations. I mean, the shoe has to fit. You really should be concerned about it. And face it, when you're doing a triennial, there may be 5, 6 evaluations depending on your child. We're certainly not suggesting that you disagree with them or saying you must. It's just, it's one of those things that we find some parents aren't aware of.
And that's a good point. Julie and I are big fans of telling families to pick their battles.
Yeah.
You know, if you really feel like occupational therapy is going just fine, but you have real concerns about speech and you have real concerns about whether the psychological evaluation that was done is an accurate picture of progress, you don't have to ask for the OT independent evaluation just because you can. You know,
Right,
just because
right.
you're allowed to do something doesn't mean you should.
Right.
And, you know, we want you to maintain a good relationship with your district and they with you. That's usually a long haul.
Right.
Yeah.
I think it's your turn.
Yes. You have a right to consent to some, but not all testing. You have that right. And in the moment, it can be hard because most of the time we do put it all on one form, but a parent can certainly say, I agree to this testing, but not this, and I would like you to write up a different form for the ones I consent to. What I will say is that it's usually inadvisable for a parent to refuse testing of almost any kind that a school wants to do, because if later there is a disagreement about the appropriateness of the programming, the school district will rightly so say, well, we didn't really feel like we had accurate or complete information because we wanted to do this testing and you wouldn't allow it. So it's not usually a good decision to refuse it. Better to allow it and then ask for the independent evaluation if you don't agree with the evaluation results.
And I'm going to read one more thing from this chapter
woman
because
who
I
has a
know we
question.
were going, what's that?
She has a question. Sorry.
Oh, sorry.
okay.
Go ahead.
So there is no specific
Right.
right that you have to limit the way in which testing is done. I mean, there are protocols and there are requirements that testing, you know, not be culturally biased. I mean, there's a whole section of the statute that talks about things that testing can't do, but there's nothing like that there's no right a parent has in that regard. As a practical matter, what I do, because this happens to many students, is we put on the record at the IEP meeting that we want to make sure that the testing is done in a way that disrupts their educational experience as little as possible. Because I have seen kids when they go through intensive testing where their behaviors spike, or you know, all of a sudden they're being pulled from class all the time, they get more and more anxious or whatever the situation is. So you want to make sure you've documented that you're hoping that they'll do it this way.
Yeah.
But schools have a timeline that the minute you sign consent, they've got to get it done. So they are anxious about it sometimes. I encourage parents to be very thoughtful and creative about, are you willing to bring your child in on an afternoon that maybe your child would normally be doing something else and it's not such a big deal? I mean, work with the team, try to find a way to make it happen with as little upset as possible, but it's a problem, it's a challenge. And if you notice any changes in your child's performance or behavior, and also you want to make it clear that you're not just concerned about it in terms of the disruption to the child, but you're concerned about the
results.
validity of the
Sure.
results.
Absolutely.
Because that can happen,
Right.
yeah.
But I think that's where just common sense comes in, and you can have a conversation with the team and say, look, I'm really concerned about this.
Yeah.
Can you be thoughtful as possible? The one last thing that I'm going to read from this chapter is, since the IDEA does not require that the IEE requests be made at an IEPT meeting, you can request an IEE of your district separately in writing. Consider writing to your child's administrator, case manager, or whoever chairs her IEPT meeting as follows. Dear whomever, I disagree with the evaluation that the school district has performed on my child. Insert name, date of birth, whatever. I am requesting an independent educational evaluation at public expense. Insert the area you want tested. Please let me know whether the district will be agreeing to the IEE, and if so, please send me the district's criteria for the independent evaluators. If not, please be sure that I am notified when the district files for a due process hearing without delay to defend its own evaluation. Many thanks. So throughout the book, we give you simple, if you want to communicate with your school district about a certain something, here's just a simple sample letter.
So,
And many people don't know that you can ask for an IE outside of the IEP team meeting.
yeah, many times districts will then say, well, we want to convene an IEP
Right.
meeting to consider it. And there's nothing that prohibits that as long as they're not delaying the process. As long as you don't end up where 3 months later is the first time you can get together as an IEP team meeting and that IE request has been out there languishing for months. Because the whole point is to get this child evaluated as quickly as possible. Okay, so, if the school district agrees to it, the school district's supposed to pay for the evaluation.
And being that when you think about one of the cornerstones of the IDEA is FAPE, a free, appropriate public education. So I always like to tell the story that if you live across the street from a student who doesn't have an IEP, and everybody gets onto the bus every morning and nobody gets a bill for that. I mean, we pay for it through our tax dollars, we all know that, but nobody gets a bill. So in order for your child who has a disability to receive a free, appropriate public education, but there's an expense to you, then that's actually discriminatory. That's why the children are entitled to a free, appropriate public education, regardless of whether they have a disability or not. And so that's the premise behind that.
Okay, so it's a very, very complex question, but I'll do my best. If the school district obtained the evaluation, consented to an IE request and said, yes, we'll pay for it, then the school district is entitled to the evaluation, okay? That doesn't mean they own it, but it becomes part of the child's educational records, which are private. So even though there is often a lot of sensitive information and almost all educational records that involve students with disabilities, that information cannot be disclosed to a third party without the parent's permission. There's FERPA, which is the federal statute that governs educational records, sort of like the educational version of HIPAA, which prevents schools from just disclosing information through records that way. The IDEA has privacy in your expectation to privacy in your records in that as well. There are also other statutes that govern it as well. If you privately have your child evaluated, you're not required to share it with the school district. You're not. I don't usually think that's a good idea, but you're not required to share it with the school district. You have to provide informed consent for any testing that the school does, whether they do it or they have somebody else do it, and it has to be informed consent, and you have a right to say no. You have that absolute right. The trickier, more law school-like question would be whether or not the independent evaluator has the right to maintain records. They have requirements to maintain records in most states for certain periods of time, just as all professionals do who maintain records. So the ones that get harder are, and both of us have had this happen with clients of ours, where the district agrees to do the independent evaluation and then tries to influence the way it's written, either by asking for drafts that they don't send to the parent, or we've had true fraud in situations where they've actually sent, we won't pay your bill unless you change the paragraph that says shall to should, or or may, or I mean, we've had these situations that we're brought in, again, we're jaded, we're brought in when things are pretty bad, right? So I would say that most of the guidance that the U.S. Department of Education has provided and the courts have analyzed surrounding independent evaluations is that it's supposed to be truly an unbiased view of the child. And if a school district tries to exert control over that evaluation in a way that flies in the face of the right to the second opinion that's unbiased, you probably would have a procedural violation. Does that answer your question? Okay. Okay, this chapter is called Toothless IEP. Did you have a question? Okay, go ahead. Okay, so you're talking about not criteria for IEEs, but criteria, yeah.
What are the criteria
Yeah,
for
yeah.
this, that, or the other thing? What that?
Yeah, so it's a good question, and there are many practices. Now, Julie, one of our favorite things to tell people is, when somebody says our policy is, you should say, thank you, may I please have a copy of that policy. The word policy has meaning, and it means that some group of people voted it in, okay? And it should be in writing somewhere. A practice is something different. A school may have a practice of having IEP meetings on Tuesdays.
Yeah.
If they have a policy that says we only have IEP meetings on Tuesdays, that might be problematic. So first of all, know the difference between practice and policy, okay? Now, a practice like that is not necessarily illegal. Courts and the Congress expect that schools are going to try to be efficient, and that they might have, so as one example, parents often ask me, all of the kids in my town go to, who are elementary aged, who have IEPs and have significant needs, go to this one school which isn't my neighborhood school. They're all sent to a different elementary school. While I would argue that, and the law prefers that students with disabilities attend their neighborhood school, that's part of the least restrictive environment provision, that we want kids to be in the program they would be in if they didn't have a disability. Courts have said, and Congress has said, you can pool resources as a district. You can say, we've got 5 speech pathologists who all work at that school because they're all students with intense needs, and we'll transport you across town. Again, it would be an individualized analysis. And if you're in a city where that transportation means you're on a bus for 45 minutes when you could be down the road at your local school, I would certainly argue that that may be more restrictive. But there are some bumpers, to use your word, to what schools can do, and as long as it doesn't fly in the face of the parents' entitlement and their rights, they probably can do that. But we do get worried anytime there is this is how we do it.
So
right?
and there is, part of the statute is that IEP team meetings must be scheduled at a mutually convenient time. And so I often run into this because, parents will say to me, well, they only offer IEP team meetings on Tuesdays, and I'm looking at my calendar with, I'm like, well, that's 4 options for the whole month, and I can't do any of them. And by the way, they can't do any of them either. So what I simply do is I have my parents write a very nice, friendly email, basically saying, I understand that it is your practice to have PPTs only on a Tuesday. However, I can't make the 4 Tuesdays a month, those 4 options, and it's my understanding that you are supposed to have IEP team meetings at a mutually convenient time for parents, and therefore we are available on these dates, and we certainly hope that you will consider accommodating us. Usually that does the trick, because when you think about if you only hold PPTs on a Tuesday, it's great if you could make it, but that's only 4 days a month. And for some parents who work or whatever, that may not be easy to pull off. If you can pull it off, great, don't make a deal out of it. But sometimes it really is a hardship. So again, write a very friendly email saying, I can't do this, and will you please consider other dates, and cite the fact that it's supposed to be mutually agreeable, and that usually takes care of it.
Yeah. Okay, this chapter is called Toothless IEP Language. In virtually every lawsuit involving a child with an IEP, where the court must determine if the parents' or the school district's view of the child's education is accurate, the court will start with the IEP. The IEP functions much like a contract between the parents and the school district, and just like with a contract, language matters. We hope you never find yourself in a courtroom looking at the language of your child's IEP in litigation. But you still need to be able to hold your school district accountable for following your child's IEP. And if the IEP itself is nebulous or has language that is so up for interpretation as to be meaningless, you're never going to be able to do that. Worse, the educators working with your child won't even know what they are supposed to do in order for your child to receive a free and appropriate public education. We get a pang in our gut every time we hear or read certain phrases in IEPs because we know all too well they mean almost nothing and allow for much too much wiggle room. This slippery language gives no assurance that a program will be carried out with fidelity or even at all. For example, as needed. As in, Johnny will receive behavioral support as needed. This means he may never need it and he may never get it. Up to, as in up to 10 hours of instruction per week. So then is anything under 10 okay? Like none? Access to, as in Sally will have access to assistive technology in the classroom. Well, so do all the other kids. And how is that individualized, and how often will she use it, if ever? Upon request, as in Mika will receive extra time upon request. Whose request? What if she doesn't ask for it, but she still needs it? With assistance, as in with assistance, Ryan will button his top button. How much assistance? What, if anything, will Ryan have gained as a skill by the end of the year with this kind of support? with hand-over-hand assistance, as in with hand-over-hand assistance, Joanna will brush her hair. Think about this one. Is Joanna doing anything here? An expert I like calls this the dead man's test. If it can be accomplished on a dead person, then it has no role in an IEP. So this is where, we really, in the moment, it can be very hard when you're sitting around that table with a lot of people to hold the team accountable, and we get very accustomed, all of us, to language we have used, so we still use it. But really, the example I give to teams all the time, and it happens to be helpful, I think, for educators to understand as well. My client could move tomorrow, and this IEP goes with them. And you may have a practice in this building that always, when a child's IEP says have access to assistive technology, that means that they have a laptop in front of them in the building, and in the classroom. That may be your practice, and that may be happening, and that may be wonderful. But they could move to California tomorrow, and the new team doesn't know your school and doesn't know your building, and it's not in the IEP, and they need to be accountable for what that document says. So that's just the easiest way to look at it. Is that if an educator who is new picks this up and doesn't know what has to happen, then it's not going to happen in all likelihood. So that's just something that we feel very strongly about, is being very careful about the language in IEP meetings.
For the purposes of time, we thought we'd end there and then take questions, because I think we get kicked out at a certain time.
Yeah, we've got about 20 minutes, I think, before we have to wrap up, so.
Questions?
Yeah.
Oh, good, lots of them, that's
Yes.
good. Go ahead. Well, colleges can accommodate, but they can't modify work, right? And so under the ADA, you're entitled to accommodations, and the school can say what they think is reasonable, a reasonable accommodation or not. But modification, which is actually altering things, no college is going to do that. So what I always like to say is that if your child has modifications and they're college bound, you want to start early, junior high, high school. What is our fading plan for those modifications to be fade away and to get rid of them? Because you're only setting your child up for a big fall, potentially, if they're still having tons of modifications, because this just ain't gonna happen in college, right?
So let me say a few things. First, the educational records that a school, a college would obtain are not necessarily going to be the special education records. And in fact, there are cases that talk about how schools cannot use report cards in such a way as to make it clear that the child is in special education. So that
Right.
you shouldn't be able to look at a child's transcript and tell
Right.
that they're an IEP
Right.
student for a number of reasons. This is one of them. And so realistically, unless the parent and or child are disclosing to a school that they are a student with disabilities and or need accommodations at that admissions level, theoretically, it should have no impact. I say theoretically because I tell people all the time, just because something is legally impermissible doesn't mean that things don't happen behind the scenes or conclusions are drawn. I analogize this to the question that some parents ask me when they call before their child's identified, but they think they should be, which is there a stigma associated with special education? And this answer, I'll give you the same answer. There's a bigger stigma associated with not having skills. And for my money, I would much rather that I know that I'm going to a college that has the supports and services that my child can be successful versus setting them up for a situation that they can't handle it, because that's not going to serve anyone well. So, a lot of times we have the desire to get into a certain school, but is that the right school for the child? We're really lucky. We live in a time where colleges and universities have gotten the message that there's a whole population of
Right.
people out there from whom they can take tuition who have disabilities, and they should be catering to this population. So we live in a lucky time that
Right.
way.
And just one more point to that. If your student is going to college and they have a disability, you still need to prove to the school that there is a disability when you go to the disability office and apply for those accommodations, and you have to disclose. That doesn't mean you have to show them your IEP.
Right.
But you have to show some proof that you have that disability and how that disability impacts you. The other option, of course, is to not disclose, but then you can't get accommodations.
Right.
But nobody's entitled to see that or find out that you were in special ed.
When a student from age 3 in Connecticut, in some states 5, but from age 3 through graduation or the exiting of services, for those students who are eligible for the IDA services, the obligation under the law is on the district. It's an affirmative obligation on the district. When you get into adult either education or services and employment, that flips. The obligation then becomes on the student or the family to seek out those accommodations. It's not an affirmative obligation on the entity that receives the funding. So that's why really good teams plan for high school students early on as part of their IEP that accessing and learning about their rights and how to access services on college campuses or in housing or employment should be an IEP goal, part of the transition goals. That's something we should be working on, teaching our students how to ask for.
And in Connecticut, transition services must be in place by 16, but I've heard there's legislation pending for it to start as early as 14.
It used to be 14 in Connecticut.
Yeah, and when I'm involved, I always want parents to start as early as possible because there's a lot to accomplish.
Yeah. You had a question? Okay, let me unpack that.
Right, yeah.
First of all, there's no requirement that either a principal or a vice principal be there. There's a list of who has to be in the IEP meeting, and it includes somebody who's able to commit the resources of the district and who's available to speak to testing, a regular educator if the student's supposed to be in regular education, definitely a special educator, the parents, there's a whole list, the student when appropriate. There's a list of IEP team members, okay? If nobody's there with authority, and we have I think a couple of chapters on this topic because we've had so many families go to IEP meetings where nobody's there to answer their questions, especially in larger districts. If you're asked to be waiving the attendance of certain people, you don't have to say yes. And you can simply say, no, I'm not going to waive their attendance and we have to reschedule. I encourage people to be reasonable about that, of course, but if you've been really upset for months about how the special education programming is going and you walk into the meeting and the special education teacher isn't there, but they have somebody else who happens to be a certified special education teacher, they may meet the requirements under the law for having a special educator there, but that doesn't mean it's going to be a productive meeting. So, and it does happen. You show up at meetings and sometimes it's clear that this is not the team you need or want. What we have in here is some sample letters to avoid that. So if that keeps happening to you, so that you send an email in advance saying it's important that I intend to be asking for the following things at the next meeting, can you please be sure that you have somebody there who can speak to my requests, so you're not reinventing the wheel all the time. But you don't have to sign those papers, but I would say, and you don't have to do it in a way that's nasty, but you certainly, if you don't feel like the people are there that need to be there, you can say I need to reschedule.
We go to IEP team meetings all the time, and to a certain extent, it's understandable that people have to leave or they've got a commitment or whatever, and you've got that revolving door thing going on. And to a certain extent, some of that is acceptable, and then there are times where it becomes almost disruptive. I always like to make sure that there's a special educator there and the regular educator there, and oftentimes they'll ask, can the regular education person be dismissed? And most times, if we're done with that person and there really aren't regular education issues we need to discuss, you want to be reasonable, say, okay, that's fine. But oftentimes I've had to say, you know what, we actually have some questions for you. Can you not leave until after we discuss this? Or you know what, I'd actually like you to stay for the whole time. It comes down to being reasonable and what's going to make sense for what you're tackling at that particular meeting.
And to that end, sometimes you feel like you're being rude. Sometimes you feel like you're being rude, or terribly unreasonable because they're asking for something, and you just, the reality is that you need that person there. And what we always say is, you know what, this is not a popularity contest. This is not who's going to go out to dinner with the administration. This is your child, and there's not someone in line, as Julie's mom used to say. There's no one in line behind you to advocate for your child. Okay, so if you don't feel like you're going to have a result for your child that your child requires, sometimes we say to parents, get over feeling badly about it. You don't have to be a jerk about it, but if you don't think that they're ready, then they're not ready.
Yeah, we actually advise not being a jerk about
We
it.
do.
Just
We prefer
be
that.
polite. Yeah.
Yes. It's a tough one. It's a tough one.
yeah.
Parents don't have a right under the law to select who works with their child, nor frankly should they. And frankly, schools don't even put into the IEP the individual, they put into the IEP the provider. Meaning their discipline, and for good reason. People move, they leave.
Right.
Lots of you don't want to be out of compliance because you said Mrs. Jones is giving this service, right? That said, of course, there are times where it's just a bad fit or something's happening, and what we encourage you, and is one of I think the first chapters in the book, is your special ed director may not know who you are. We are big fans in building relationships, and if you have a good relationship with your director, you can go in without because some of it is we all have jobs, many of us do, or we've had them in the past, if we don't now. And we know that sometimes there's politics in employment relationships, and sometimes a manager has to be appearing like they're standing behind their team, even if they have reservations about it in the meeting. So sometimes being behind the scenes and saying one-to-one to an administrator, I'm concerned, my child's exhibiting this behavior, can we switch, can we do it? And sometimes there's a face-saving device of how to do it, some way that doesn't make anyone look bad, where that can happen in middle school in particular, or high school, where you can say, well, let's just switch them out of this elective, and then it changes the whole schedule, and problem solved, right? That is not always a problem solved, but, there are sometimes creative ways you can do it. But in terms of a legal right, the right to choose the individual is not one that parents have under law. That said, hearing officers don't like to hear that a school let a child suffer with a bad relationship for periods of time, or heaven forbid something worse, without intervention.
But it's always a good idea to document it. And, just emails, I'm terribly concerned, I'd like to meet with you, and just keep at it, and hopefully better heads prevail if it's really something that is in nobody's best interest.
Yes. So actually, if what you're asking is how can we have students with disabilities have access to sports and things of that, we already have it. So non-academic and extracurricular activities are envisioned by the IDEA to be those programs that students also may require special education services in order to access and to provide, and the U.S. Department of Education about 2 years ago issued a very strongly worded document to school districts, which sometimes they do, saying you cannot deny access to non-academics and extracurriculars to students with disabilities, and in fact, you're supposed to be providing support for that.
But school-sponsored, that may not apply to a town league.
It may not, although you might have a 504 issue if the town receives federal funding, which they do.
Right. Well, have you ever heard of unified sports? Is that something, have you ever heard of unified sports?
Which isn't integrated with students
Unified
with
sports
disabilities
is something
and
that
students.
districts will, you usually need to get a group of people together to make sure that you've introduced the idea of let's have some unified sports, and that's where it's a mix of typically developing peers and students who have IEPs. And it creates an opportunity with some more structured sports activity. But that may be
students with
something for you.
disabilities have every right and access to the benefit of participating in non-academics and extracurriculars as students who do not have disabilities. In fact, one would argue that that is the crux of the anti-discrimination provisions of Section 504, which is a different law, but it also falls under the IDA. So as an example, we've had clients who want to join the ski team. What that may mean is that the school district finds a paraprofessional who also knows how to ski, who can accompany the child so that they can participate in the ski team.
Well, you should
not
ask for
easy.
that in your IEP team meeting, because that's an IEP issue. And don't ask for it outside of that. Make it part of the IEP.
Yeah. It's sort of the next, in my opinion, the next wave of where we have a few areas where we just haven't come that far. I mean, relatively speaking, the statute's about 40 years old. It's come a long way, but we have a long way to go, and I think schools are just starting to realize how important including students with disabilities in those non-academic and extracurricular activities.
But one of the things that you can do is, what's the name of that, that guidance? The one on extracurricular? If you could.
It's a Dear Colleague letter, I believe, yeah.
You could provide that
It's in
to
our
your
book.
school district and say, I just want you to consider this in my request that I've made for my son or daughter to be involved in XYZ sport. And do that in your IEP and bring that guidance letter with you. We can certainly,
I think it's in the book.
if you give us your information, we can, shoot that off to you in an email or something.
Yeah, it's a January
Oh.
25th, 2013 letter from OCR, and in the book on page 180, there's a link to it, so, okay. You're welcome. Yes, if you build it, they will come, right?
It's usually parents that will help get that off the ground because, and you have to work with your school district to make that happen.
So one of the things we encourage is if your child's IEP, in order for it to be implemented appropriately, that paraprofessional needs specific training on that disability or on a methodology or whatever it is, we encourage the team to spell it out in the IEP, either on page 8, there's a little paragraph at the bottom, a little rectangle that's called frequency and duration of supports. It's a place where a lot of times in an IEP document in Connecticut, we will list those kinds of supports that are necessary. So monthly paraprofessional training with dyslexia expert or whatever it is. I mean, I don't, it doesn't necessarily mean the team's gonna agree to do it, but if you feel that there's, and there's documentation, so that's where those outside evaluations or the district evaluations are good sources of data. If it's clear that this child requires a para who has this level of training and it has to occur, you put it in the IEP so you make sure that not just any para is gonna work with the child.
And sometimes, depending on the circumstances, you might want to, you can ask, well, what do your paras get trained at, and actually ask for it. I mean, I'm not always saying this is for every single situation, but then you can point out, well, that training doesn't cover, let's say it's their particular area, but it doesn't cover a child who might have hemophilia, as an example. And they need to be very specifically trained on how to react if that child gets cut, as an example, just to give you an example. Well, you can request that very specific training, and for whatever it might apply to. Then there's one step further you can go, and that is to say that you want to get in place fidelity and integrity checks, and that person, because somebody has to always be responsible for the para. Somebody has to, one of the educators, the certified educators, has to be responsible for that person's performance. So you can get in place that you want fidelity and integrity checks, and what is it that you're measuring and what are you looking for? It's kind of getting into the weeds a bit, but if you can go there. Because oftentimes I find with paras, and there's some wonderful paras, but sometimes there's not a lot of training provided to them, and they're just off doing their best, and being held to a certain standard. Here's what you have to do, and somebody's going to be making sure that you do this with fidelity and integrity. And I find most paras actually want that guidance. They're craving it.
Any other questions? It's one data point, there are, I assume, others, but yeah, I mean, you could certainly, if you feel that the child's not on grade level, and, I mean, there's, the analysis is gonna be not just, the very few cases rise or fall on one data point, so it's the teacher's report, how you, from her parents' perspective, how you feel that she's doing, then, of course, those standardized measures as well. But certainly, if you're heading into a summer and your child's significantly behind on district-wide testing, that's the point you wanna raise. Yeah.
And do print out that extended school year criteria.
Yeah.
That should be very helpful to you.
Yeah.
Okay, because regression is not the only standard on which to make a decision.
Yep, there's been a case that's gone up and down in the Second Circuit out of New York City that has really good authority, and we actually have I litigated a case here in Connecticut at the hearing level that adopted some of the language of that court. Basically, the upshot is that the courts have found in our circuit that if bullying does interfere with a student's ability to access their education, then it is a violation of the IDEA. And what's important is that the courts have looked at sometimes, and we know this from a lot of, Julie and I have had a lot of clients like this over the years, sometimes the student's disability is changing their perception of whether the bullying is happening. So we may have kids who are, let's say in an accusation of 10 times in a month they've been bullied, maybe twice they were actually bullied, but they perceived it 10 times because they overreact to situations, or they have social skills deficits, or whatever it is, to understand language, and they think they're being bullied constantly. What the courts look at isn't really necessarily whether it's actual bullying, although they do look at that under bullying laws, but they're looking at the child's perception of their safety in school, and then therefore their access to their education, and that child's perception is the reality. And particularly if it's because of the disability. So it's a factual analysis like any other, but we have very good case law on bullying leading to a deprivation of an IDEA program.
And what we generally say is bullying can be addressed in the IEP. If your child is being bullied, or your child is the bully, which sometimes happens as well, at the end of the day, there's skills around that we all need to have to navigate that. And there could be many layers underneath it. Some children may not even be able to correctly identify what is bullying. So you sort of have to peel back the layers, but you should be asking for IEP goals to address whatever the issues are, the skills that are needed around it.
Self-advocacy is just one example.
Identifying it, who to go to if you don't feel safe.
So it's obviously a valid topic to discuss in
Oh,
Oh,
yeah. We have a whole
absolutely.
presentation on it.
Yeah,
Yes,
yeah.
bullying can be addressed in the IEP.
Yeah,
Yes, yep.
yes.
Yep. It's a very good question.
Right.
There are some people who really insist on every instrument being spelled out in that consent form. Most of the time, I advise parents, unless there's some real reason on a particular instrument that we have either an issue or a request, that they consent to the discipline and who's going to do it, which is how most districts in Connecticut do it on the form. So it doesn't say we're evaluating OT, it'll say fine motor skills, and then they'll list some tests and who's going to do it. The reason is that good evaluators will sometimes change what they originally thought they were going to be doing based on the performance on the evaluations, and they may want to dig deeper or do something else, and you don't want to have to get the meeting together, get in the form signed, and all those things. So again, it's like a reasonableness thing. There may be reasons why you distrust the evaluators on your child's team enough that you want every instrument spelled out, and sometimes it's important because some tests there's a practice effect if it's done within too often within a time period, a year or 2 or 3 years, depending on the test. And sometimes parents don't realize that, and they have their child evaluated outside of school, and then 2 evaluators are doing the same test, and it invalidates the results. So you want to have as much information as possible, but again, we want you to be reasonable.
But from a practical standpoint, I think it's very reasonable if they're saying fine motor, gross motor. Can you tell me the idea, some of the names of the tests that you think you're going to do? Because I find as a parent, you want to be able to know what is going on. So you might want to write it down. You can Google it to figure out what it is. They may not insist on having it written down, but at least you can discuss what some of the and they may end up changing their mind. But then you can say, hey, if you change your mind, would you just give me a heads up?
Sure. It's your comfort level on that one. And also, you have to be told what instruments they did do. I mean, when they get the report, when you get the report, it should tell you what they did. It shouldn't just be, fine motor skills are fine, So really, it's gonna sound like such a lawyer's answer, but it really is, it depends. And that's where the unique needs of the child absolutely come in. What I would argue is that the practice that many districts have used over many, many years throughout the country of just adding 1 more year of progress every single year when there's 2 or 3 years apart is doing nothing. You're just kicking the can down the road, and the child has aged a year and is no closer to meeting goal in a year. So, you want to be ambitious, and now under Endrew F, certainly ambitious would be reasonable. However, there are some students who may never close the gap, and the school district is not going to be found to violated the law because a child who doesn't have the ability to close that gap doesn't close the gap.
But you can certainly, if you believe that your child is closing the gap, that's certainly a reasonable expectation that you should be asking for.
Right.
Absolutely.
That's where looking at IEPs cautiously comes in, because if you look at goals, very often you'll say, so in 1 year, they're going to be still 1.5 grade levels behind. If they meet the goal, you have to be thoughtful about what it really means. Any questions? Okay, we're happy to sign books for anyone who brought them, and so glad you came. Thank you.
Thank you so much. Thank you.